What is quantum meruit, and can you incorporate quantum meruit into your contract to fight the client when they want their deposit back? On this episode, stick around.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, everybody. My name is Rob. I am a wedding lawyer representing wedding industry professionals. And in this week's video, we are going to be talking about the concept of quantum meruit, what it is, and is this something that we should incorporate into our client contracts. But before we get into the specifics of that strange Latin term, I want to take a step back and talk about some broad concepts in contract law that are going to bring quantum meruit into better focus for us. Now, typically in American courts and courts located in the United States, there are typically two remedies that you're going to ask the court to provide to you depending on your situation. The first idea, the first concept is a legal remedy. Then there are equitable remedies. Legal remedies are almost always money. We call it damages. Legal remedies, typically you're asking the court to provide you with damages, money. So this is if you've been injured in a car accident, if your copyright has been infringed, if you've been defamed on the internet, or if you've had your contract breached, you're going to be asking the court most of the time for legal remedies, for damages, for money. Now, legal remedies, set that aside. Now, what about equitable remedies? This is when you are asking the court to do you a solid, to do you a kindness, to do something out of the concept of fairness that money might not fix for you. So, for example, if your neighbor has erected a fence on your property, perhaps money is not going to help you. It's going to require the person to disassemble the fence and put the fence where it needs to be. You are asking the court to make someone do something or not do something. We all have heard the term of temporary restraining order, like Rob can't go within 500 feet of Harry Styles, something like that. That is typically an equitable remedy. Like I said, whenever possible, a court is going to want to provide you with damages, money, rather than the equitable remedy. That's just how it shakes down. Courts typically don't like to tell a defendant or a third party to do something or not do something. They just want to, here's money, this is the best way we can to compensate people. So a lot of times, equitable remedies are there because a legal remedy is not available. Okay, so let's look at a couple of wedding examples. So let's say that you're a wedding planner. You've signed the contract with the client. You've done all the work. You've done the walkthroughs. You've selected the vendors. You've done all the work up to the day of the event. The day before the event, the client cancels. Now, typically what you would do in order to be made whole is to file a lawsuit for breach of contract and ask for the legal remedies of damages. You're going to be asking for expectation damages most of the time. And I would say go back to episodes 8 and 9 if you want to have learn more in depth about the concept of suing a client for money if they've canceled the event and expectation damages. But in the nutshell, everybody, you are going to be asking the court to give you money to make you whole. But now let's use the same example, but let's say that client is 16. So you go to sue the client who's 16 for a breach of contract, and the court says, well, hang on, sorry, Charlie. It's typically not possible for a minor to contract, and therefore you have no contract at all. And if you have no contract at all, you can't sue for breach of contract. So in this instance, you're going to ask the court for an equitable remedy. Like, look, I don't have any legal remedies from a technical standpoint, so I'm going to ask the court for the equitable remedy. And in this instance, where a contract fails, where a contract cannot help somebody, that is when you would request the court for what's called quantum meruit, which is Latin for what one has earned. You are asking the court not for breach of contract damages, putting you in a place that you would have been had the contract been fulfilled. Here, quantum meruit is asking the court to give you the money equal to what you have provided to that client. It's restitution for the work, maybe the out-of-pocket expenses you've put into the work based on a contract that you thought existed, but in reality does not exist. That is, for the most part, how quantum meruit works in most jurisdictions. It is an alternative to suing for breach of contract when there is no contract. So now a question that I'm getting is, Rob, can I incorporate the concept of quantum meruit, or can I have some type of quantum meruit clause in my contract such that if the contract fails for some reason, if the client is 16, or maybe due to force majeure, or maybe due to some type of issue of impossibility or impracticability of the contract, then we would revert to quantum meruit damages. That's possible. There are contracts that where the client is agreeing with the professional to do that. I have seen those. Now, here is so that is actually it's possible that you can do that. Again, you're going to want to talk to an attorney in your area. But here are a couple of issues that I would stress to you to think about before you rush to put the idea of quantum meruit in your contract. That is, the client, you're going to at least pay me what I've done if we can't go forward. Okay, so here's a couple things. Number one is, I would be worried about getting what you ask for. So there are a lot of times in which one party thinks the contract doesn't exist and the other party does. And so to the extent that force majeure or some type of issue of impossibility is in the mix, it doesn't necessarily mean that the contract is void or that there is no contract. So if there is a contract and there's just a disagreement about whether or not it can go forward, then typically expectation damages, the damages from breach of contract, a lot of times are better than quantum meruit. So you as the professional are going to be on stronger footing if you don't have a quantum meruit clause in your contract. And I hope that's making sense. And we're getting a little bit super in depth into this, but typically I don't want to confuse a judge. If a judge picks up the contract and it says, "Oh, you're going to get quantum meruit damages," then it's possible that's all you're going to get, even though, no, Your Honor, it's still a contract and I want expectation damages. It's adding a little bit of extra confusion into the mix when you don't necessarily need to. It's an extra thing for some judge to try to figure out. So that would be one of the main things that I would be concerned about. The other thing is this: the COVID-19, force majeure, impracticability, impossibility is continuing to change. I can't tell you, depending on what jurisdiction what jurisdiction you're in, whether or not force majeure is going to apply, and I can guarantee you your client can't either. Okay, so avoiding the idea of quantum meruit altogether might be better for the reason I just explained, that the law is constantly evolving and the concepts are confusing, and you don't want to confuse somebody that could potentially, issue a verdict saying somebody has to pay you money. And going back again to the idea that typically damages from a breach of contract action, suing the client because they breached the contract, typically is going to net you more money than quantum meruit, because one aims to put you in a place that you would have been had the contract been fulfilled, and the other just gives you the money that you're potentially out. So, well, Rob, then what should we do if it's not best practices to put a quantum meruit clause in, or to, you don't want to confuse things, then how do we protect ourselves from all of these situations from the past year in which the client cancels because of COVID-19 and we don't know the value of what we've done or how to keep the money and how to stay out of court. Okay, so if you want an in-depth conversation about this, then it would be great for you to go back and watch episode 25 of this podcast, which is 4 tips for a rock solid force majeure clause. I go step by step into kind of fighting refund requests based on force majeure, based on COVID-19. But the long story short on that, how do we address that, is to, number one, make sure the client understands that if the event can't go forward for reasons beyond the party's control, that is to say COVID-19, tornadoes, pandemics, whatever it is, that does not dissolve the contract. The parties will make best efforts to reschedule. The parties will make best efforts to reschedule, and if the parties don't want to, or if the client doesn't want to reschedule, they are in breach of contract. The contract has gone nowhere. It's still there. It is still enforceable. And by the client saying, you know what, COVID-19 is a force majeure event and I don't want to reschedule, they're in breach of contract. Making it obligatory in the event that there's a force majeure thing that the client has to go forward, that is probably going to do you a lot better than having a quantum merit clause. The other thing is that you want to make sure that, and again, this is, if you want to watch episode 9, where I talk about keeping money if the client cancels, and that deals with if the client cancels on their own accord, accepting multiple non-refundable payments oftentimes will save your skin in those situations as well. So again, rather than having a quantum merit clause in your contract, it may be more beneficial for you to have a force majeure clause that covers the idea of whether or not you're keeping money if the event is canceled due to a force majeure event, obligating the parties to move forward and rescheduling, and therefore you just keep the money and go forward. These type of things, in my opinion, are a little bit better. So I'm not saying that the quantum merit clause is not right for you. You would need to have somebody look at your contract, depending on what jurisdiction you're in and depending on the language of the contract, it might be okay. But by and large, you're going to be better attempting to keep the contract whole, keep the contract going, because expectation damages, that is breach of contract damages, typically are much better than quantum merit or restitution damages. And hopefully that wasn't extremely confusing for you. If you've got any questions or comments, if you're enjoying the content of these videos, please be sure to hit the notification bell, to like and subscribe, and then like and subscribe to wherever you're getting podcasts from. This is going off in all directions. It's on wherever you get your podcasts from. It's on YouTube, on the website. Let me know how I'm doing. Have you had any issues with quantum merit? Do you have a quantum merit clause in your contract? Let us know about it. Let's talk about it. We'll have some more conversations about this. Until then, folks, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.